Welcome to the Wealth Multiplier podcast. If you've been here before, welcome back. If you've not been here before, welcome for the first time. Today, we are joined by Steve Parr, a lawyer at Parr Business Law here in Vancouver. And we're going to be talking about how business owners can set themselves up for success when it comes to succession planning. So how do you get the business to transition from one generation to the next generation? Usually these are privately held family business. We talk about the structures that you need in your operating company, holding company, trusts. We also talk about the different types of documents that you need as far as the estate part of that. So your wills, powers of attorney, representation agreements, and how do those all play into successfully transitioning your business from the one generation to the next generation. And then we're going to close it out by talking about the importance of shareholders agreements. So these are the agreements that, the documents that helped all of the owners of the business be on the same page, and also to plan for the best and the worst that could possibly happen into the future. So if it's all right with you, we're going to get started with Steve Parr right now. Steve, thanks for joining us today.
Absolutely. It's a pleasure to be here. Thank you.
I'm going to let you create your own thunder. Do you want to tell us a little bit about your background, kind of how you started, how you got here?
Yeah, absolutely. So my name is Steve Parr. I founded Parr Business Law 8 years ago. So I'm a lawyer, of course. And prior to that, I was an entrepreneur. So I had started a vacation rental management company and then sold it a few years later. So I had that experience of what it's like to grow a business, to deal with my own advisors. I had lawyers who were working for me as well. And then to actually transition out of the ownership role. So that cued me to some of the issues that entrepreneurs face, particularly when they're engaging advisors and legal advisors in particular. So I started my firm 8 years ago, and I've since grown it into both a corporate practice and an estate planning practice. So we basically specialize with working with families of business owners. So business owner grows the business, and then they need to figure out, how do I pass this thing on? How do I sell it to a third party? Should my children be involved? And so we help them, guide them through those conversations and take care of all the planning that needs to be done.
So very similar conversations that we have with our clients, except you're just looking at it from the legal side and we're looking at it more from the financial, insurance, investment side.
Exactly.
Same types of stuff. How do you structure it? Where do you put things? How do you involve the family? How do you involve outside shareholders or stakeholders and things like that? Mm-hmm. Do you want to describe maybe a couple of your top couple of clients, just so we can kind of set the tone of who we're speaking to the most here?
Sure. Yeah. So, I mean, for example, obviously I can't share names, of course, but it's one of our clients. They are a manufacturer. They manufacture parts for the trucking industry. We'll just leave it at that. And what they do is they sell across Canada and to the US. And so, but they're very much a family business. So they have all manner of different family members, cousins, brothers, sisters. It's a real family operation. And they've been in business for over 20 years. And they have considerations around, well, how do we maximize the value of our business if and when we sell? They don't know what their exact horizon timeline is for selling, but they want to ensure that they're able to take advantage of some of the tax exemptions that exist within Canada, the most important of which is the lifetime capital gains exemption. So that's one of the objectives that they had when they came to us was, well, how do we maximize this? We have a lot of different family members who are involved in this business. Is there a way that we can reduce our potential tax liability to the greatest degree possible?
And then, so how do we do that? It's going to be some sort of structure that we're going to put together.
Yeah.
Potentially through setting up the right types of companies. Maybe there's some trusts involved. Mm-hmm. What does that look like if we've got a family business, multiple people working in the business, and you want to maximize that lifetime capital gains exemption?
Sure.
And I guess even let's define what is a lifetime capital gains exemption. Yeah. Like just for...
Absolutely, yeah. So the lifetime capital gains exemption currently sits at $1.25 million in Canada. Mm-hmm. And this will go up year after year. Historically, it's been indexed to inflation. So we're in a sort of a more dynamic inflation environment. So we'll see what happens with that. But it will go up over time. So it's $1.25 million, which means that, and it applies to a capital gain. So but only certain types of capital gains.
Right.
So it's applying to capital gains upon the sale of qualified small business shares. And so the shares are only qualified as such to be eligible for this exemption if they pass 3 specific tests. And these tests are fairly detailed. It's something that you're going to want to discuss in detail with your corporate lawyer and with your accountant and your financial advisor.
Yeah.
But the high level of it is that the tests are oriented around, are the vast majority of the assets inside of the business actively being used to generate profit and carry out the operations of the business. In other words, you can't have a whole bunch of passive assets inside of your operating company, i.e., say you're running your operating company, your trucking business, and then you're acquiring a bunch of real estate. And you're like, okay, we want to get into the rental management business. So we're going to acquire a bunch of condos and earn passive rental income there. That's going to put you offside of the lifetime capital gains exemption rules.
Yeah.
But that, of course, is one of the issues that comes up. A fortunate issue when you are running a profitable business is that you have excess cash and you want to invest that. And so that's the type of structuring that we look at. We're thinking about, okay, well, how can we take this excess cash, make use of it profitably so that the shareholders are able to realize a return, and also keep them on side of their eligibility for that exemption.
Right.
Yeah.
Okay. So yeah, the lifetime capital gains exemption allows you to get up to $1.25 million in capital gains tax free, if you do it the right way and if it's structured the right way. And then again, say we've got a family that has multiple people working in the business. How do we multiply that stuff?
Yeah.
If I have one time 1.25 million and then brother or sister or parents probably, how do we also get theirs?
Yeah, well, absolutely. I mean, going back to this trucking business, for example, in this instance, there's actually 5 shareholders of the business. So there's 5 siblings who are all involved in the business, right? So they're all shareholders of this one particular operating company. And so what we did in this instance is that rather than holding their shares directly, either personally or through their own personal holding companies, because one thing to keep in mind is that a holding company is not eligible for the lifetime capital gains exemption.
Right.
So if the HoldCo sells the shares of the OpCo, you're not going to get that exemption. The exemption is only available to individuals, to personal individuals. So what we did there is that we had them exchange their shares, whether they were holding them personally or whether they were holding them through a HoldCo. We had them exchange their shares for what are called preferred shares.
Yep.
So these are called fixed value or preferred shares. And then we set up family trusts. So each of these 5 shareholders, they all created their own family trust. And then they were able to designate their children and other persons that they wanted to designate as beneficiaries under this family trust. It's called a discretionary family trust.
Yeah.
And so those trusts came in to subscribe for the growth shares of the original operating company, the trucking company. And so then future gains would be able to be flowed through those trust companies, flowed through those trusts and then distributed to the beneficiaries. And that can include down the line, if they do sell the shares of the trucking company, the proceeds from that sale. Those can be flowed through the trust to the beneficiaries. Sorry if I'm jumping ahead, but there's one of those beneficiaries is going to be a holding company.
Right.
So for each of those 5 siblings, each one of them is going to have their own HoldCo that's a beneficiary of the trust. And that's what allows them to continually pull out excess cash so that they can put it into that holding company and then invest from there.
Right.
Yeah, whether it's into securities or into real estate or other assets.
Yeah. It's very similar to kind of how we don't give this type of advice, but we do let clients know that they should ask these questions to the lawyer so that this is the advice that comes out. But yeah, having the operating company, the holding company, the trust, and then sounds like another holding company on the other end, is a very tax efficient way to generate the money in the operating company, flow the usually retained earnings up into one of these other structures, and then be able to get that out with this lifetime capital gains exemption eventually whenever you trigger that.
Yeah.
And I guess also from, does this also then flow into the passive income rules that changed a few years ago, where now we're not allowed to make too much money passively or take away a small business deduction?
Yeah. I mean, unfortunately, it doesn't really get around that. You can't really circumnavigate that using this type of structure, simply because of the association rules.
Right.
So,
right, they're associated companies.
Yeah, there's the HoldCo is an associated company to the OpCo. So that small business deduction is going to be ground down, by passive income to a certain degree. So at a certain point, there's going to need to be other mechanisms that are going to be put into place. And to my understanding, I think that's where a whole life plan can come in handy.
Yeah. You can put that inside the holding company,
right? Yeah,
and store the retained earnings inside there, and then the whole life is tax exempt if you do it right.
Yeah, exactly.
Yeah, and then if I've got this company and I'm running my operating company, what kind of triggers do I look for to say, okay, well, now I should set up a holding company, or now I should set up a trust? Like, what? Obviously, there's expense that comes along with setting these things up. There's work that comes along with setting these things up. And then on an annual basis, you have to maintain these things. You have to do extra tax. You have to do your taxes twice or three times. Sorry, you don't do your taxes three times, but you have to do taxes for yourself and for your operating company and for a holding company and for the trust. What kind of triggers would say, okay, now is the time to do this?
I mean, it's something for you to discuss with your financial advisor and your accountant in particular. I think it really does come down to, well, do you see yourself selling this at some point in the future? Really important to keep in mind with the lifetime capital gains exemption is that there's a 2-year holding period. So you have to be qualified for those 2 years preceding the sale. So, sometimes the sale of a business can be unpredictable. We don't always know exactly when we're going to be selling the business. Some circumstances might change, that maybe there's some big material economic circumstances like tariffs or what have you that sort of force a sale or that make it more attractive on a shorter time horizon than you had originally anticipated. So it's putting into a trust allows you to be prepared for the unknown. But certainly if you have any kind of thought that, this might be, I might want to sell within the next 2 to 10 years, it's well worth it to get it done, provided that, your business is profitable enough and is going to be
worth selling.
Yeah. I mean, obviously there's no point in putting a whole bunch of complex tax strategies if you don't have a profitable business. But, if your business is generating significant retained earnings, perhaps, what the threshold is, it really depends on who you are as a business owner. But, some of the clients that I've worked with are generating retained earnings of $250,000 to millions of dollars each year.
Yeah.
And certainly when it's, in the millions, it's absolutely worth it, because that business is likely going to fetch a pretty penny on the open market. And feel like I didn't fully explain the multiplication of the lifetime capital gains exemption.
Yes.
Because each of those, so going back to our trucking company, we had 5 shareholders and they all have their family trusts now. So let's just say that the sale price is, for easy math, $5 million. So it's $1 million to each of the 5 shareholders. So they'll easily be able to account for that. That exemption is going to capture the entire amount of that. But let's just say the sale price was $50 million. Then it would be $10 million to each shareholder. And so if it was to go to one individual shareholder, you'd still have $8.75 million of unexempt capital gain that's going to be taxed at the marginal rate, right? So the multiplication happens where it goes to the family trust, and then if there's 4 other beneficiaries there, each of those 4 beneficiaries can use their own individual lifetime capital gains exemption because it's attached to an individual person, right? So that would be what, $6 million?
Quarter, yeah.
Yeah. So, five and a quarter. Yeah.
Right.
Yeah. So 1.25 times.
No, 6 and a quarter.
6 and a quarter?
6 and a quarter.
Yeah.
Would be tax-free through the lifetime capital gains exemption. And then the remainder would be taxable,
would be taxable
as a capital gain. So half of the remainder.
Yeah. So I mean, at that point, you're realizing an absolute tax savings of well over $1 million.
Yeah.
So,
which is important. Like it's significant, right? Like, would you rather have that money in your pocket, or would you rather send it to Ottawa and then they can decide the best use of that money? I think generally our clients feel that they know better what to do with their own money than.
Well, absolutely. And I mean, these tax exemptions also exist for a reason. They exist to incentivize entrepreneurship. I think, well, they should, because it's the driving force of our economy.
Right.
So, so it's important to make use of these things.
And then, so that's the positive outcome there. What do you see? Have you seen any sort of like big mistakes, or, oh, this shouldn't have happened like that? Like, or do people try to DIY this, or?
Not a lot of people DIY a trust structure. I actually haven't come across that. It's just too complex.
Right.
Entering into the structure it always requires complex work, So, some clients, of course, do DIY some of their own accounting or legal work, but generally you don't see that at beyond a certain level of sophistication, right? And certainly when you're contemplating entering a trust structure, it's you have to engage professionals. I guess just where I've seen it go wrong is where clients didn't do it soon enough.
Right.
They didn't do it soon enough, and then all of a sudden they have a pending sale. They've received an attractive LOI from a third party. Perhaps they weren't anticipating selling so quickly, but then a buyer came along and they weren't prepared.
So I would like this trucking company. Yeah.
Exactly. Yeah. And again, like, we don't always know like what's going to happen with the marketplace. Of course, we live in a very dynamic, highly unpredictable environment now. So, yeah.
And then we're both online a lot, and we've both got pretty good YouTube followings. So we get a lot of people messaging us from YouTube, and we appreciate you. But they also see a lot of American content online.
Yeah.
Where then, so we're talking about trusts in Canada under Canadian trust rules, which are significantly different than the American one. So sometimes people come to us thinking that if you set up a trust, you're going to magically never pay tax ever again.
Yeah.
Is that, and I don't know how it is in the US, but that's kind of the impression that we get, is that how it works in Canada is a trust just a magical tax-free thing that lasts forever?
That would be nice, right? Unfortunately, that's not the case. And trusts are very different in Canada than they are in the US. I'm not an American lawyer, so I can't give you the full ins and outs of how it works down there. But I do a lot of estate planning. I have a lot of estate planning lawyer colleagues who are south of the border. And one of the things that a lot of people do south of the border is set up trusts on the individual basis. Mm-hmm. Because what you can do down there that you cannot do here is roll over your assets into the trust without incurring a deemed disposition, without it triggering a disposition of those assets, which in turn triggers a capital gain.
Right.
So in Canada, when you do that, when you roll assets into a trust, and by roll, I mean transfer assets into that trust, then you're going to trigger a gain. And which is why when we're talking about the trucking company, we're not rolling their existing shares into that trust, because if we did do that, then we'd be triggering the gain.
Right.
So we're
freezing.
Yeah. And then transferring the future growth of trucking company into that trust.
Right.
Yeah. So that's a really important distinction too. And all the more reason to put it into a trust earlier, right?
Because then the share value will be lower.
Yeah.
And it'll grow inside the trust on a different.
Yeah. And have dramatically different tax consequences, right? Because when you transfer your existing common shares that you hold into preferred shares, then those preferred shares are going to be sold as part of the business when you sell trucking company. And because those shares are held personally, you're going to have some exemption available, your personal exemption available. But if it exceeds the $1.25 million, then you're kind of out of luck,
right,
for being able to capture that under a multiplication exemption situation. So, I mean, really, if you have a business that is growing and the aggregate value of it is going to be north of a few $1 million, then you should really be strongly considering a trust.
Right.
Yeah.
Okay, cool. So then it'll look like something like operating company, holding company trust or operating company trust holding company.
Yeah. Like, if we had a whiteboard, it'd be like OpCo. Sometimes there is what's called a like a buffer company between the operating company and the trust. That's for complex tax reasons that your accountant can explain. It's about avoiding what's called Part 4 tax.
Yeah.
But yeah, there's the operating company, then there's the trust, and then there would be beneficiaries over here. And one of those beneficiaries is likely going to be a holding company, so that you can flow through money without that money hitting yourself personally. Because of course, when income comes and hits yourself personally, it's going to be taxed at your personal marginal rates. Whereas you could simply move up the money from the OpCo through the trust. It's a flow through entity, and then it lands into the holding company as an intercorporate dividend.
Right.
Yeah. So it doesn't trigger any additional tax.
Right.
Yeah.
Okay. Cool. And then this is something that we talk to our clients a lot about, and we draw that exact same picture with the little triangle and the square and the circle.
Yeah.
And like, so in this structure that we've set up here for this, in this case, the trucking company with the 5 siblings, the parents would own it now. And then you were talking about estate freeze along the way there and preferred shares. So that would mean that basically the parents started the company for $100 and now it's worth $5 million. There's a gain there from 100 to 5 million. And that gain will potentially continue to grow as this business becomes worth more and more and gets bigger and bigger.
Yeah.
But when we transfer to the kids and we do an estate freeze before setting up these or before putting the shares into these trusts, how does that work and what does that mean?
Sure. Yeah. So the estate freeze is essentially the process of converting the common shares that they own. So the parents own these shares that are now worth $5 million. The initial cost was $100 when they subscribed for them originally. So rather than having to pay tax on that gain when they transfer those shares, they're going to swap them. So it's under a provision under the Income Tax Act Canada called Section 86 in this instance. So there's a few different rollover mechanisms inside of the Income Tax Act, 51, 85, and 86. And in this instance, it would be 86 because you're exchanging common shares within an existing company for preferred shares within the same company. So they would trade out those common shares, take the preferred shares, and those preferred shares now have a fixed value, right? Whereas the common shares before, their value is dynamic. It fluctuates with the ongoing value of the company as is determined by the company accountant or by a certified business valuator, however you want to do it. But they would say, okay, it's December 31st, 2025. As of this date, the value of the shares is $5 million. I'm exchanging those common shares for preferred shares, and say there's 2 parents. So each of them now has preferred shares worth approximately $2.5 million each. And so what that means is that they've fixed their future tax liability, So maybe they're able to claim the lifetime capital gains exemption on the sale of those shares. Maybe they're not, because perhaps they've already used it at an earlier point in time, or whatever. There may be other factors that affect that. But yeah, now they know what their future liability is going to look like, and then the trust at that point, if we're still working with that example, can subscribe for the common shares, which are zeroed out in value because all of the existing value of the company has kind of been sucked out of it and frozen and crystallized into these preferred shares. And so the trust can come in like a brand new, fresh baby shareholder.
Right.
Yeah.
Okay. And then one thing where we kind of fit into place with the insurance part is now that we know that the parents are going to have this eventual tax liability and we know how much it is, somebody's going to have to pay for that. Generally, the cheapest and most guaranteed way to do that is to have an insurance company pay for that. And so you can say, okay, well, we need $2.5 million the value is $2.5 million, figure out what the tax is on that. And we need some sort of insurance plan that's going to pay that amount one day when your parents are no longer there.
Exactly. Yeah.
And then that's one way to kind of, when you're transitioning the business, to lock in the value that the parents have created up to here, and then the kids take it over from here, and then their value is now starting from where they took it over, and then their tax liability is going to grow into the future, and we don't know what it's going to be and how big they're going to make this company or what the tax rates are going to be in the future.
Yeah.
But that is kind of, with this structure, you got to do a couple moves in between. You're working with your lawyer, you're working with your accountant, really, and you want to share as much information with them as possible so that they can really understand your situation and have a full, clear picture of it. Because sometimes, some people also don't necessarily want to share all their information, and that makes planning more difficult, or it makes planning wrong, which we've had that situation in the past where people didn't share all the information, and then you find out later that what they did share was not enough, and then there's this huge problem that we didn't even know about.
Yeah,
that can become really expensive.
Absolutely. Yeah. No, it's vital as clients to find advisors that you feel comfortable with, and because it's a bit of it is a team sport. No one advisor can do everything. That would be nice, but that just doesn't exist. Some people talk about having family offices at a certain level of wealth that becomes more practical and financially feasible to put in place. But the reality is, generally, you're going to have an accountant, a corporate accountant who's familiar with this type of planning, is familiar with trusts, is up to date on all of the compliance requirements, because they are becoming increasingly complex. There are more compliance and disclosure requirements around trusts that exist now than ever before. And then, of course, working with a corporate lawyer and with a financial advisor, particularly somebody who understands insurance as a mechanism for funding the eventual tax liability in the most tax efficient way possible. Because it's easy to miss opportunities here. It's easy to miss the opportunity to set up this structure in the first place to save yourself the tax, and then it's easy to also miss or mess up the planning around insurance too. So you really need to be working with people that know their stuff and that you trust and that you can share absolutely everything with, because no advisor can help you if they don't have all of the information. Yeah.
This is great. This halfway through this podcast, and I feel like if you're watching this on YouTube or Spotify or Apple, you just got hundreds or thousands of dollars worth of legal structuring advice that's, you're not really going to find this in a textbook, or just your general kind of business information doesn't get into this specifics of how this works. And this could save millions of dollars in your company if you're profitable, and something that you want to start doing as soon as possible. Because we often do find too, there's business owners, they spend all their time working in the business and they're making a ton of money, and then it's 20 years later and they look around and they're like, oh, we should have probably done this, but we didn't stop to actually do it, and we didn't talk to anybody, and now it's way more expensive to do, or it's way more complex.
Yeah.
Let's shift gears, I guess, into the future a little bit, and we talk about the estate part of it. So we've done the corporate structure, and then now it's the estate part, and it's really essential for the business owners to think about your estate, or to think about how are you going to transition this to your kids or to your grandkids or to a charity of your choice or whoever you want to. And, you want to ensure that continuity, minimize tax, minimize headaches, and just have a smooth process. Why do you see entrepreneurs kind of failing or delaying to do the estate planning part of it?
Yeah, absolutely. So estate planning is a big part of my practice, and I'm very passionate about it because it's so important. It's something that absolutely everybody needs to deal with at some point in their lifetime. And generally, it's something that you want to be revisiting throughout your lifetime, because your circumstances and your desires, your wishes are going to be changing. People don't deal with it, of course, because it's a heavy subject. And nobody really wants to be contemplating the fact that you will die, that I will die, you will die. We're all here on borrowed time, and it's a finite kind of experience that we have here. Which is stating the obvious, but it's a simple truth that people do not want to accept or acknowledge, or perhaps they feel some sort of superstition around, like, well, if I'm drafting up my will, then somehow it's going to expedite death.
Yeah. And it's cultural too sometimes. Some cultures just can't talk about it, and you're just like, oh, you probably should. Yeah.
No, absolutely. There's sensitivities there as well. And it's challenging. And I think beyond simply the confronting our mortality component of it, it also, doing your estate plan also means that you are taking stock of the status of your relationships.
Right.
So if you have a strained relationship with your children or with a sibling or with your parents, anybody in your family system, then when you're doing your estate plan, you have to take a little bit of a look at that. And that can be uncomfortable too. But I think that that's all the more reason to engage in the process, because that can be a very healthy thing. It can be a very healthy thing. It can say, okay, you know what, like things that haven't gone exactly how I wanted them to go with X person in my family system. Maybe there's an opportunity here for me to have a conversation, Because estate planning is not just about getting the will done and the power of attorney and the representation agreement done. Like those, of course, those are absolutely essential documents and they do need to be done. But estate planning is really about having conversations, and it's about having conversations, especially when you are a business owner, because if you've created something that has value and that you are hoping that the next generation is going to be able to take advantage of some of that value and enjoy some of the legacy that you've built, because, let's face it, building a business is really hard work and takes decades of patience to really do it right. You could very easily be leaving a lot of money on the table and also setting up the next generation for some really difficult emotional conversations that, that could have been navigated around much more cleanly by the parent themselves. I think a lot of parents, unfortunately, whether it's because they don't want to deal with this or they're just like, they'll deal with it. Let the kids figure it out. Let the kids figure out whether they want to take over this business, sell it or whatnot. Or even if it's something like the family cottage, or some other asset that's inside of the family system, they just think, let the kids sort it out. And that's a terrible way. I'll just call a spade. Like that's irresponsible.
Irresponsible is a good word.
I think it is irresponsible. Yeah. And, I'm not in a place to judge or anything like that, but the reality is that the parents created that thing, which is amazing. You created the family cottage, you created the business. That's incredible. But a part of the responsibility of creating something and bringing it into the world is to think about how it's going to pass on,
It's not just about starting. You got to also close.
Yeah, you got to close. Yeah, you got to finish the job.
Yeah.
Yeah.
So I guess from on the estate planning side, you mentioned will, power of attorney, representation agreement, which just for quick, the will is what happens when you die. Power of attorney is allowing somebody to make financial decisions for you, and representation agreement is allowing somebody to make medical decisions for you. So if you can't tell the doctor to unplug you, then you've written this down, the unplug you or don't unplug you. What other things should we be thinking about as a business owner beyond that?
Sure. Yeah. So the will, of course, it grants authority to another person. The executor is generally what they're called. They can also be called the administrator. Mm-hmm. Generally, that is a term that's employed when people do not have wills.
Right.
Then you have an administrator of your estate. But in any event, there's an executor who's going to be legally obligated to enact the wishes that are expressed inside of the will. So, so the will is very powerful for setting up things like a trust. Right. Again, like trust is so confusing because the trust that we were talking about earlier on in the podcast, that's a living trust. That's a trust that exists during your lifetime. We're talking about a trust that's created by virtue of a will and doesn't exist until the will maker dies. Yeah. But then there's the most important thing around these trusts is for the care of minor children, So if you have minor children, chances are you do not want them to receive
millions of dollars
when they turn 19. You probably don't want them to receive $100,000 or even $50,000 in 19, because that's way too much money for that young of a mind. And they need more maturity. They need to have the opportunity to grind, to hustle, to figure out who they are. Not enough money and too much money can both spoil a child. Right. Absolutely. So a staggered trust is generally what most people do. They'll allow some amount of money to be distributed to the kids at age 25, at age 30, at age 35. There might be some other conditions that are attached. It also permits the trustee. The trustee is often the same person as the executor, although it does not have to be. It allows them to have some discretion over when what other purposes the money might be used for. So education, starting a first business, down payment on a home, things like that.
Those are usually the big life milestone.
Yeah, exactly. Life milestone pieces. So yeah, that's that. And then, the power of attorney, exactly. It's for granting legal authority to another person, generally when you become incapacitated, although not always. Sometimes some of my clients do choose to grant that authority to another person while they're still able to make decisions. And some people also create a separate business power of attorney from a regular power of attorney, right?
Right.
Because generally your power of attorney, your main one, you're going to grant to your spouse. But if your spouse has absolutely no clue what's going on in the business and has no concept about how to manage it and doesn't want to manage it, then you should be thinking about creating a separate business power of attorney to a trusted person.
Would you set up a separate business will as well?
Yes. So if you have private company shares, then, and if you have that, going back to our earlier example, you've got that holding company, for example, say that holding company has $5 million of assets or $10 million of assets, then when you set up a corporate will that allows you to, or a business will, it's called a variety of things, restricted will, secondary will, etc. That will does not need to be probated, which is hugely advantageous for two main reasons. The first reason being that you save the probate fee, 1.4% in British Columbia. It's higher, slightly higher or slightly lower in different provinces throughout Canada. But so in BC, if, for example, was a $10 million holding company, then that would be $140,000 of probate fees.
Right.
And of course, that's after tax income too. So that would be
like 200 grand,
250 grand, it's a lot of cash, right? So that's really beneficial. The second reason being that it's faster. You don't have to go through the probate process. Probate can take years. Sometimes I generally say to my clients, you're looking at a minimum of 3.5-4 months to get things done. And that's if they provide us with all the information immediately. If we're not backed up, if the probate desk is not backed up,
right. If everyone likes each other,
if everybody likes each other. Yeah. I mean, if there's any kind of difficulty after you file what's called the P1, the notice to the other beneficiaries, then you could be looking at years. So a corporate will allows you to transition that wealth much faster, which can be really important, of course, too, if the operating company is inside of the corporate will. If those shares of the operating company, then you're risking there's a far lower risk of disruption to the business.
Right.
Yeah.
Because the plan is there.
The plan is there. The control remains the same. There's less uncertainty.
And then does the business remain operational while the estate is probating, and how does that?
Yeah, I mean, as long as there is a plan in place,
Right.
Yeah, I mean, the business, of course, does not need to shut down or be frozen during the process of being probated. But until it's probated, then there's not going to be clear authority over who can sell the business if that's a desired outcome. Yeah. Okay. And there can be issues if it's around legal authority. So there may or may not be somebody who actually has signing authority if that hasn't been thought through ahead of time. One of the things that some of my clients do is they'll set up a director's resolution appointing somebody else that can be enacted at the point in time that
if something happens.
Yeah.
Okay.
Exactly.
Cool. So so in the case of, say, like the trucking company with the 5 siblings, ideally they would have had this done in advance, which it sounds like they did because they came to you.
Yeah.
And then so now the 5 siblings would be in charge. And if something happens to the parents, it doesn't matter. Well, it matters because it's your parents, but it doesn't affect the business as much. And then you've got 5 people that are in there ideally running it and they know what they're doing.
Yeah.
And they're doing a good job, hopefully. So again, planning and doing your plan in advance. One of the things, so I'm part of the committee that hosts the estate planning summit here in Vancouver. And a great thing that somebody said from the stage, one of our presenters years ago, he said, your succession plan is going to happen.
Yeah.
Whether you wrote it or whether you didn't write it. Because if you wrote it, it's going to ideally happen the way you want it. And if you didn't write it, your succession plan is going to be either a heart attack or cancer or a divorce or a death.
Yeah.
And those things are going to happen whether you planned for them or not.
Yeah.
And then how do you want this to transfer? Do you want it to be clean or do you want it to be messy? And who are those people receiving it? Do they want it to be clean or do they want it to be messy?
Yeah.
Because that's, we've seen some nightmare stories of just people who haven't done it. Even in our industry, people who counseled other people to do it, but didn't do it themselves.
Well, exactly. Like we're both advisors.
Yeah.
So I've got my clients, you've got your clients, and we have a huge responsibility as advisors to make sure that this is done. Because, if I die tomorrow, if I get incapacitated, hit by a bus tomorrow, then, I need to have a plan in place. And thankfully I do have a plan in place to ensure that there is some continuity of care for my clients, that they're not left in the lurch, that they're going to have somebody that they can contact, who's going to be taking care of their files. Yeah. Because otherwise, then it falls upon the professional regulator, and it's a huge, ugly process. It's ugly for the clients. And of course, arguably more importantly, it's going to be really ugly for the surviving family that are, dealing with the grief of losing somebody or seeing them in the hospital, and how they have a professional regulator and hundreds of clients who are
calling them every day,
trying to figure out what's going on with their situations.
Right. Yeah. It's and with our industry as well, actually, some of the licensing bodies require some sort of continuity plan,
as well they should,
in order to keep your license.
Yeah.
Which is, how do you see the coordination between like the legal tools and the financial tools? Like what kind of financial strategies are these guys putting in place to pay for things, or to, we talked a little bit about lifetime capital gains, the deemed disposition on death, or paying for these kind of things. How do you see that?
Yeah. Insurance is really the first thing that people start to consider when they're putting these plans in place, because insurance really is the lowest cost solution in aggregate for dealing with this. And there's also some tax advantages that I think you could probably illustrate more effectively than I could, around whole life policies that can really make a ton of sense for these business owners.
I did not coach him on this.
No, it literally is like, it's something that almost all of our clients are looking at, because insurance just makes sense when you've got something. If you've gone down, let's just say, like, if you're a client and you've gone far enough down the road that you're thinking about setting up trust and planning for the future, planning for an eventual sale, that means that you are a forward-looking, long-term thinker, right? Who is taking into consideration your own future needs, but also the future needs of your family members. So I would say that if you already have that mindset, then insurance is just going to be a natural next step, because it just starts to make sense. I think, again, people sort of avoid the topic of insurance for similar reasons that they avoid doing planning for their corporate structure or doing their estate planning. Again, because insurance sort of triggers these uncomfortable feelings of, well, it's life insurance,
somebody's going to die.
Somebody's going to die, and like, who cares who gets what after, which is the mindset of somebody who's, not really thinking about other people.
Yeah. We've definitely run into that. Who cares? I'm going to be dead, so let them sort it out.
Yeah. Like great. not the kind of people that we work with,
Yeah.
We can't really do a whole lot for people who are not interested in the benefits of planning, and that's fine.
Yeah.
Yeah.
Cool. And then, so say there's multiple people in that business. I know the shareholders agreement is important here.
Yeah.
How does that work? Like, why is that so critical to the multi-owner business if we've got 2 or 3 partners?
Yeah. So generally, the shareholders agreement is important for so many different reasons. And actually, I just recorded a video yesterday.
Oh, cool.
It's not online yet, but maybe I'll try to get a link on this video when it is up, that details some of the reasons why a shareholders agreement is important. And I won't rattle them all off because I'd be talking for the next half hour.
Okay.
But some of the basic ones, I call them the 4 Ds. So death, disability, divorce, disagreement.
Okay.
So
makes sense.
Death, you have 3, 4 shareholders, one of them passes away. Then if there's no planning whatsoever, then the surviving 3 shareholders are going to be dealing with the estate of the person who passed away. So that means the estate, and whether that is that person's spouse or that person's children, now they're all of a sudden a de facto business partner of the 3 surviving shareholders. And that, probably isn't going to work out all that well.
Right.
And probably is not what the estate wants either, the surviving spouse. They don't want to be dealing with this business. They just want... So a shareholders agreement will generally include some provisions that allow for those shares of the deceased person to be bought out automatically at a fair price by the surviving shareholders or by the company itself. And generally, that purchase is going to be funded through insurance.
Right.
Because usually, of course, businesses don't just have a couple $1 million sitting around to buy out in anticipation of somebody dying and potentially buying out their shares, right? So it makes a lot more sense to pay, whatever it is, a couple $1,000s a year or whatever it is. Of course, these structures vary quite differently, to fund that buyout should that be required, because that allows the business to keep going and minimize disruption, and for the estate, very importantly, to get to realize something from the investment that person made into the business.
Okay, so death, disability.
So disability, of course, if you have a shareholder, if you have a small private company, generally the shareholder is going to be active in the business. Should one of them become disabled, then after a certain period of time, depending on what the shareholders have agreed upon, they may want to have them sell their shares in the business. So similar to death, they're no longer able to participate in the business. And they probably have liquidity needs, because if they're disabled, they're no longer able to work. They're going to have financial needs that need to be met. So again, you can have a type of insurance policy, a disability insurance, sometimes critical illness insurance comes into play as well, to fund that purchase, right? Divorce. Yeah. So divorce, again, like in BC, the Family Law Act, shares in a company are not excluded property. So excluded property is what is referred to as property that's going to be not subject to division under the Family Law Act. And unless there's a cohabitation agreement or some sort of spousal agreement that exists, then those shares might well end up being divided. So again, that might trigger a compulsory purchase by the other shareholders or by the company.
Because I don't want to be in business with your
disgruntled ex-spouse. Yeah, exactly. Not a fun time. And then disagreement, simply having some mechanisms in place. So should the shareholders just not get along anymore or decide that they really want to go into a different direction, then you want to have some mechanisms in place to resolve that dispute. There's a variety of different ways that can go, whether it's mediation, arbitration. Sometimes you might have heard of like a shotgun clause. So that's sort of a situation where if you and I were 50-50 on a company, I could put out an offer to you and you would have an opportunity to match that offer, to either accept that offer or throw it back at me and say, okay, I'm just actually going to buy out your shares. So that's one way, of a very crude way of resolving a dispute inside of a business. And a shareholders agreement is a governance document. So it will set out what kind of decisions require the unanimous consent of all of the shareholders and which decisions can be made by a smaller majority.
Yeah. And then this kind of falls into like the good paper makes good neighbors, right? Having up front, everybody knows where they stand. They know what the rules are. You can move forward confidently knowing that if things happen, we don't have to invent how to solve it, especially in a tumultuous time.
Yeah.
Because if one of those 4Ds is happening, you don't want to be trying to figure out how to do this. You want to have it written down that, okay, well, now this is what's going to happen.
Exactly. And trying to figure it out when one of those circumstances is happening is the absolute worst time to be trying to figure it out. Yeah. And it's an exercise in planning and forethought and in forcing some conversations between the shareholders that ultimately should really help clarify what kind of relationship they want to have going forward.
With all of those, there is some sort of buyout of those shares. How do we figure out how much those are worth? Like if it was a public company share, you could just look on the market and say it's worth whatever the market says. But with a private company, say we have a trucking company, how do I know how much it's worth?
Yeah, so there's a variety of different ways of going about that. If it's in the context of a shareholders agreement, often a certified business valuator is going to be brought in because they're accountants who are specifically trained on how to value businesses. So much like a real estate appraiser, they're going to be able to come in, look at the financials, look at the economic outlook, and look at the strength of the management team and a variety of other factors and come up with a price. And if there is dispute between the shareholders, and of course sometimes there is, one party wants a higher price, the other party wants a lower price, then there might be a mechanism that's baked into the shareholders agreement to have two different certified business valuators and then take the average of the two. Right. There's a variety of different ways of doing it. But yeah, generally the expectation is that the parties are going to arrive at a fair market value. And in less contentious situations, then they may well be able to amicably just agree upon a price. And of course, that's the preferred outcome. Yeah.
And then with a shareholders agreement, is this something that I can just download a template off the internet, or is this something where it needs to be specific for our situation, for the people that are in it? And
yeah, it's highly specific. And the problem with downloading a template from the internet is that you aren't thinking through the questions that need to be thought through, and you're just flying into the unknown, really. A template from the internet is just not going to cover off this kind of situations that you want to be thinking through. And you're not working with an advisor who has sort of been there and done that. You're truly flying blind. A lot of the provisions aren't going to make any sense whatsoever. And it's, a shareholders agreement is not a one size fits all. There's a huge array in the types of shareholders agreements that we've drafted, some of them being extremely simple. The shortest that we've seen is around 15 pages, and some of them are, close to 100 pages long.
Oh, wow.
So, yeah, it can be really quite complex. And it really just depends on, they're very much bespoke to each business.
Okay. And then what are, like, I don't know, 2-3 things that, where you would see like weaknesses or like a poorly drafted, because we want to know what to look for, but we also want to know what to look out for. So what are a couple of things to look out for?
Yeah, I mean, the insurance provisions are pretty important. So if you are contemplating, like, generally life insurance, whole life insurance in a business corporate context, that's going to be held by one of the holding companies, or perhaps each individual shareholder's holding company. So there are some complexities there in terms of how the payouts work.
Okay.
And there's, and I'm sure you talk about this with your clients, the capital dividend account. So yeah, that's a tax-free mechanism to pipeline out cash from the proceeds of a corporately held life insurance policy to the shareholders tax-free. Mm-hmm. And so you want to make sure that is set up properly. And if that needs to be set up correctly inside of the shareholders agreement, and if that's not set up properly, then you could wind up with a massive tax liability that was not intended whatsoever. So that's one of the key provisions. The other things like thinking through confidentiality provisions, thinking about non-solicits, non-competes, and then also thinking through, okay, well, if the business falls on hard times and needs an injection of capital, or if it is in growth mode and again needs some more capital, and you're looking to raise it internally rather than going to a venture, then you want to be thinking through, like, well, how do we deal with that? And if one of our shareholders has deeper pockets than the other, then how do we reward that person without unduly punishing the other party who can't contribute to the same level?
Right. Okay. Cool. Yeah, those definitely some things to think about there, for sure.
Yeah, and those are just a few. I mean, those are just sort of 3 that are top of mind. But honestly, like, there's just about a dozen really key points that come into play. So whenever we work with a new client for a shareholders agreement, we have an extensive intake form that they're going to fill out. And it's a bit of a discovery session to really understand the business, understand the personalities and the financial situations of all the different shareholders, and really arrive at a comprehensive kind of portrait of what the business is, where it is right now, and where they'd like it to go.
Okay, cool. We're coming up on time here. Anything that we haven't talked about? So we talked a little bit about like the holding company, trust company setup, the structure of the business. Talked about some estate things to consider. So like your wills, your powers of attorneys, how does that work? And then we talked about shareholders agreement, kind of 3 major parts of how do you grow your business, how do you pass it on, and how do you make sure it's protected. Is there anything that we didn't bring up that you think that people should definitely know about? Or,
I mean, I think we covered a lot, so I don't want to like throw out any more technical pieces or things for people to consider. I really think the most important thing is just for people to get started on this. Talk with your existing advisor, or if you don't have an advisor that you're working with right now, feel free to reach out to us. We're always happy to help, and a good advisor is going to be able to address these questions or refer you to somebody who can. So just don't stop until you find somebody that you are comfortable with, that's going to be around for the long haul, is going to be able to grow with you, and is able to confidently address all of your situation. It's just a really important thing. We covered a lot today. I think it's important that our listeners don't go away feeling overwhelmed, but rather that they feel like a sense of inspiration, that there are people out there who can help you, and that it doesn't need to be really difficult or onerous to go through the process. We covered off a lot of pieces here, but the reality is that once you have the clarity and the willingness to just get it done, it can actually happen pretty quickly. So, yeah.
And then where do people find out more about you, about Parr Business Law? I know you've got a big YouTube channel. Do you want to maybe shout that out?
Yeah.
Our website is really nice.
Thank you. Yeah. So it's Parr Business Law, PARR businesslaw.com. And we have a YouTube channel, Parr Business Law. So you can find us there. Just pop us into Google or to the YouTube search. And we're located here in Vancouver, British Columbia. So we're offices at 8th and Cambie. And
Yeah. And when he says YouTube channel, it's not your typical lawyer YouTube channel with 4 videos and 90 views. There's hundreds of videos, thousands of subscribers. The videos actually they're well produced and put together. And
thank you.
And you can tell that they haven't been run through layers of compliance to make it so that you're not actually giving any advice ever, and you're just fluffing through, but that it's actually saying concrete things that are useful to people to.
Yeah, as much as I can, I try to communicate things that are real world applicable. We all have a lot of things on our mind these days, and I want my viewers to be able to get the information that they need as quickly as possible. So,
and we'll link to your website and your YouTube below. You were mentioning there was something else that we were going to link to, but we'll go back through the notes and I'll remember what it was. Oh, sorry, you've made a video.
Yeah, I made a video on shareholders agreements. So, yeah, if you want to link to any of our content around shareholders agreements, estate planning, I do a deeper dive on trusts as well. Okay. So, if any of those topics are of interest to your viewers,
that's what we talk about all day.
Amazing.
And so, thanks so much.
Yeah, thank you as well. It's been really fun chatting. Thank you,
Steve. I appreciate it, and I appreciate you sharing so much information with our audience. We definitely will do this again, because I know that there's way more that we can also cover.
Absolutely. I would love to do that. Yeah, sounds great.